Okay, this is actually going to be like the first motion that was filed by Chris's attorneys, and this was filed on August the 16th at 9:14 a.m. Now, there was actually several filed on this day, several mini motions actually. This is actually the first time he went to court was August the 16th, and I will link that court appearance at the end, and it's also right here. But this was at 9:14 a.m. I can't remember exactly what time he was actually in the courtroom on the 16th. I would have to go back and look. But yeah, these are the motions that was filed in the Chris Watts case from beginning until current day, every motion that has been filed in his case. So I think these are pretty interesting, and there's several of them. There'll, be several many parts to this, but it is part of the case. And we have went through every part of this case. Discovery, body cam, we've just did it all on this channel. This first one is going to be an entry of appearance and motions regarding preliminary hearing, bond modification, appearance, and notice of rights. And of course, this is the people of the state of Colorado versus Christopher Watts. This is the Colorado State Public Defender hereby enters his appearance in this matter and hereby moves for the following: a preliminary hearing if the defendant is entitled to such a hearing upon further oral request for setting off said hearing in open court. A bond modification hearing at defendant's next appearance if defendant has been unable to post bond due to defendant. If the defendant is in custody, defendant requests to appear for all court hearings personally and objects to appearing to interactive audiovisual device. Defendant specifically objects to appearing by interactive audiovisual device at any hearing pursuant to Rules 43E and others, and requests the defendant appears personally as set forth by Rule 43. The defendant revokes and rescinds all releases, waivers, and authorizations for the release of information of any type previously made, and hereby asserts all rights and privileges to which defendant is entitled under Colorado and federal rules, statutes, and principles, including all Colorado and federal rights to remain silent and rights to cancel. Okay, this is another one that was filed on August 16th, again at 9:14 a.m. This is the motion to allow confidential defense experts to be present for forensic testing of evidence. Now, this was denied. We know that because they were not there when the autopsies was done. It was only the prosecution that was actually there during the autopsy and such. So, defendant through counsel asked this court enter an order allowing the defendant to have a confidential expert present during any specific testing of evidence by law enforcement or prosecution agents in this case, and states the state through law enforcement and other agents may perform various forms of testing involving items of evidence such as firearms, bullets, and shell casings, and biological sample testing. In doing so, the state's agents apply various scientific procedures and methods of their own choosing to the evidence. While such testing may not destroy the existing evidence, the evidence that is developed as a result of such scientific testing normally consists of the observations and subsequent testimony of the state's experts as to the methods and procedures which were employed, and their observations of the results thereof. Unless the defendant is permitted to have his or her own confidential expert present during these procedures and tests, he will have lost any realistic ability to confront the state's evidence as to the procedures performed and the results obtained. The state's experts will have a sole and virtually unchallengeable control of the evidence generated as a result of these tests. Therefore, such testing may destroy the existing evidence. For example, bullets in evidence may be fired, and the condition of other evidence may be altered by the testing. In such situations, the defendant has a due process right to have his or her own confidential expert to be present at such testing. The defendant requests the opportunity to have his or her own representative expert observe the scientific procedures and tests performed by the state. Such a representative expert would not participate in or in any fashion interfere with or influence the state's testing procedures. Such an expert would enable the defendant to have reasonable access to the evidence and a reasonable opportunity to confront that sort of evidence in this case. And in the instance, the requested relief is virtually the only method of allowing the defendant access to the evidence and an ability to effectively confront such evidence in court. The only consequence of allowing the defendant to have an expert present at the state's scientific testing of evidence is a significant enhancement of the reality of the truth-seeking function of this case, and the protection of the defendant's right to effective assistance of counsel. It is well recognized that the right to counsel any include the assistance of confidential experts. The state has no privileges or rights to confidentiality or secrecy at any point in such testing. No work product is involved. Since their work is intended to generate evidence which may be used in court, the police and other prosecution agents have no legitimate reasons for keeping their methods or procedures from the strictest scrutiny by the affected party. Additionally, defendants moves that the court order the state to refrain from performing any additional scientific testing on the evidence in this case until the issues presented by the defendant's motion to have confidential defense experts present at such scientific testing are resolved for the following reasons. A. The defendant has filed the motions above, and he expects that the issues raised therein can and should be resolved in an expeditious manner. The state would suffer no prejudice from a delay. B. Testing of the weapon or biological material and other evidence in the case would potentially be exculpatory as to issues which are material to the defense. There is a manifest necessity that a defense expert be present in order to properly document and preserve potentially exculpatory evidence. The state and court are on notice that initial testing may destroy evidence that cannot be replicated or by duplicative testing. The state and court are also on notice that testing performed without the presence of the defendant's experts will deprive the defendants of a realistic ability to confront and rebut testimony concerning such testing. D. The defendant also hereby requests that the state refrain from any scientific testing in this case until the defendant's experts are present and able to observe the testing procedures. The defendant also requests and demands of the prosecution that it refrain from conducting any such testing until such time as the issue of a defense expert observing testing is resolved. Defendant makes this motion and all other motions and objections in this case, whether or not specifically noted at the time of making the motion or objection, on the following grounds and authorities: the due process, trial by jury, right to counsel, equal protection, cruel and unusual punishment, confrontation, compulsory process, right to remain silent, and right to appeal clauses of the federal and Colorado constitutions, and the 1st, 4th, 6th, 8th, 9th, 10th, and 14th Amendments of the United States Constitution and Article 2, Sections 3, 6, 7, 10, 11, 16, 18, 20, 23, 25, and 28 of the Colorado Constitution. And then it is signed off Megan A. Ring, Colorado Public. This one filed August the 16th, 9:14 a.m. And this is a motion for protective order. Defendant moves this court for an order requiring the office of the district attorney, any other law enforcement persons, and their agents to get the consent of defendant's counsel, deputy state public defender, before attempting to contact or interview the defendant, and b, give said counsel a reasonable opportunity to be present prior to any contact with the defendant on the following grounds. 1. The office of the public defender has been appointed to represent the defendant. 2. The defendant does not wish to be interviewed, contacted, or questioned unless her attorney, and this should say his. I noticed earlier when I was reading, refers to Chris as a her for whatever reason, so it actually should say his attorney is present. The defendant wishes all of his contacts with state agents to take place through his legal counsel. Notification of consent of opposing counsel is required by the Colorado Rules of Professional Conduct, Rule 4.2. Defendant wishes to exercise both her right to silence and against self-incrimination and her right to counsel under the fan state constitution. Defendant hereby exercises her right to remain silent and privilege against self-incrimination and right to counsel under the federal and state constitutions. And it is signed off Megan A. Ring, Colorado State Public. Okay, this one also August the 16th at, again, 9:14 a.m. This one is a notice for invocation of all statutory case law and constitutional. Defendant by and through counsel hereby notifies the district attorney's office and or all law enforcement agencies of his or her invocation of the following privileges. All privileges are granted under CRS 1390 and 107. All medical and psychiatric, including drug and alcohol treatment, domestic violence, and or anger management treatment privileges afforded to defendant under the Colorado and United States Constitutions. As to all medical and or psychiatric treatment defendant has ever received. All privileges in school, employment, military, probation, prison, parole, social services, and any other records defendant has a confidentiality exception through federal and state statutes and case law, administrative regulations and rules, or federal and state constitutional provisions, or the agency's own statements to defendant, either oral or written. Defendant requests that this court specifically order that no member of the office of the district attorney, law enforcement, or any person or agency specified in Rule 16 of the Colorado Rules of the Criminal Procedure or their representative or their respective agents attempt to obtain confidential information pertaining to the defendant. Defendant does not authorize any person to waive said privileges on the defendant's behalf. And, of course, it is also signed off Megan A. Ring, Colorado State Public Defender. Okay, this one as well is August the 16th, again at 9:14 a.m. This is a motion to limit the pretrial publicity. The defendant moves for an order attached limiting pretrial publicity pursuant to the Colorado Rules of Professional Conduct, the American Bar Association Rules of Professional Conduct governing the conduct of lawyers, and the American Bar Association Standards for Criminal Justice, Fair Trial, and Free Press on the following grounds. 1. The defendant has been arrested for an allegation of murder. 2. there has already been or likely will be substantial pretrial publicity concerning this case. Rule 3.6 of the Colorado Rules of Professional Conduct, Rule 3.6 of the ABA Rules of Professional Conduct, and Standard 811 of the ABA Standards for Criminal Justice. Fair trial and fair press set forth the guidelines to be followed to ensure the defendant receives a fair trial in this case, and again signed off Megan A. Ring, Colorado State Public Defender. Okay, this one is also filed August the 16th, again at 9:14 a.m., and this is a motion to preserve and produce. Pursuant to 16 and the due process clauses of the United States and Colorado Constitution, defendant moves for an order requiring the prosecution to preserve and provide defendant with access to any and all items of evidence, including but not limited to the following items: all recordings produced or seized in connection with this case, all police notes. Defense counsel is aware that it is the practice of law enforcement to destroy their notes. Defense counsel requests an order specifically ordering law enforcement agents to preserve all notes in this case, all scientific reports, memoranda, or notes produced in connection with the events in this case, all photographs made or seized in connection with this case, all biological samples and physical evidence made or seized in connection with this case, all correspondence including email and text mail correspondence by or to law enforcement and the prosecution concerning the investigation of this case, all records and logs and receipts pertaining to the storage and movement of physical evidence. As grounds for this request, defendant states: 1. Defendant will be making independent evaluation of all items which are possible material evidence and potentially exculpatory in this case. 2. Due process and defendant's Sixth Amendment right to confront his accuser require that he be allowed to obtain such evidence. The evidence seized includes items that are material and potentially exculpatory. This discovery is authorized by the 5th, 6th, and 14th Amendments to the Constitution of the United States. So, that said, and this one was granted, and how we know this was granted is because we do know in the discovery that one of the officers, I can't remember which one it was, they come back and they had to actually remake some notes that they had taken because they had accidentally threw them away, and it was before they had gotten this order that they had to keep all their notes. Just as this order says, they typically just write the report from their notes and throw the notes away, but they ask that the notes be kept and put into the discovery as well. So that said, we do know that this one had to have been granted, right? Because we do have all of those notes, and I've read them in the discovery. And yes, the notes a lot of times have more information than the actual report that is written. We found that out as well. Lots more, really. Also, it states in here that everything that they have gotten from as evidence, that the prosecution had as evidence, that they had planned to use against Chris maybe in the trial, if there had been one, then Chris was able to independently look at each piece of those evidence. So that tells us that Chris did see the crime scene photos. He saw everything, literally everything. So yes, he has saw that. And some people has said, I wonder if Chris seen the crime scene photos. Well, I mean, yeah, he would have, unless he's just like, I don't want to look at those, which we don't know. But he actually made this motion to see everything independently, like firsthand. So definitely could have. So yeah, and this is signed off again, Megan A. Ring, Colorado State Public Defender. Okay, this one was also filed August the 16th at 9:14 a.m. And this is a motion requesting that any and all employees or technicians from any and all laboratories testify in person pursuant to CRS. Defendant through counsel hereby provides notice that the defense is requesting that any and all employees or technicians from all laboratories testify in person as to the results of any laboratory procedures received in evidence in any court proceedings, included but not limited to trial, sentencing motion hearings, and preliminary hearings, pursuant to CRS 163309. Defendant makes this motion and all other motions and objections in this case, whether or not specifically noted at the time of making the motion or objection, on the following grounds and authorities: the due process, trial by jury, right to cancel, equal protection, cruel and unusual punishment, confrontation, compulsory process, right to remain silent, and right to appeal clauses of the federal and Colorado constitutions, and the 1st, 4th, 6th states, 9th, 10th, 14th Amendments of the United States Constitution, and Article 2, Sections 3, 6, 7, 10, 11, 16, 18, 20, 23, 25, and 28 of the Colorado Constitution. This is signed off again, Megan A. Ring, Colorado State. Okay, this one was filed August the 16th, but this one, 12:25 p.m. And this is a motion for leave to file sealed motion. Weld County District Attorney Administrative Order Number 2016-01 governs electronic filing of pleadings in criminal cases. Administrative Order Number 2016-01 says that parties are permitted to file a motion requesting leave to file documents under seal. Mr. Watts moves for leave to file a pleading which will include information contained in the sealed warrantless arrest affidavit. This one is signed off by James E. Merson, the Deputy State Public Defender. So see, this one was filed from the Deputy State Public Defender, a different person. Okay, this one again filed August the 16th, 2018, but this was 4:51 p.m. Motion to allow defense expert to be present at the autopsies. The prosecution has advised that the autopsies are scheduled for August the 17th, 2018 at 9 a.m. The defense would like to have a defense expert present to observe the autopsies. The prosecution has indicated they object to this request. Just to cut in here, the judge, I believe, also denied this request because, to my knowledge, the only ones that it mentions in the decision that were present at the autopsies was the prosecution team and, of course, law enforcement and the detectives, Detective Almover, Tammy Lee. The prosecution has indicated they object to this request. Mr. Watts asked that this court enter an order allowing the defense to have an expert observer at the autopsies. A defendant in a criminal case has a constitutional right to perform independent testing of physical evidence. Prosecutional actions to deny this right constitute a denial of due process. Mr. Watts would incorporate the arguments set forth in D2. Motion to allow confidential defense experts to be present for scientific testing of evidence into the request set forth in this pleading. Mr. Watts makes this request pursuant to his right to a fair trial, his right to present a defense, and his rights to due process under the United States and Colorado Constitutions. Signed off, Megan A. Ring, Colorado State Public Defender. This one also filed August the 16th, 2018, 5:45 p.m. This is a motion to allow defense investigator to be present for the autopsies, D19. Mr. Watts, through counsel, moves this court for an order allowing an attorney and a defense investigator to be present for the autopsies in this case. Mr. Watts would incorporate the arguments previously made in D18 and D2 into this pleading. Mr. Watts makes this request pursuant to his right to a fair trial, his right to present a defense, and his rights to due process under the United States and Colorado Constitutions, U.S. Constitutions, Amendments 5, 6, 14, Colorado Constitution, and that would be signed off Megan A. Ring, Colorado State Public Defender.